Today's program is the result of our partnership with the County Supervisor Holly Mitchell and her fabulous workforce and economic development team, along with a committed pro bono attorney from Goodwin Law and the tremendous support of Public Counsel. We have joined together to bring you a program highlighting different related legal issues related to commercial leasing, a topic of a lot of interest for the community of Lake County District 2. And to tell you a little bit more about free services that we hope will help you to thrive and grow. I have the honor to introduce you Councilmember Nithya Raman. We are thrilled to have you here and thank you for joining this event. And I will give you the floor, Councilmember. Thank you for being here.
Thank you so much, Nadia, and thank you to all of you. It's so wonderful to see everybody today and to see that there are so many participants on this webinar. It's clearly serving a real need for the community, and I'm so delighted that all of you are putting this together and that we were able to partner and spread the word about it as well. And particularly honored to be working with Supervisor Mitchell's office to create this opportunity for business owners and for commercial tenants, and also to continue to be working across city and county to partner to make sure that our resources, our rules, our regulations are working in tandem as much as possible to keep people protected. COVID-19 obviously impacted everyone, our government, our schools, our family, and businesses took a huge hit. One of the issues that we've sought to address in our office is the issue of commercial rent debt. As more and more businesses in our district contacted our office to express concerns about mounting debt, we realized that while the city had done a lot on individual rents, so on people's rents in apartments and protections around those, the issue of commercial rent debt was equally large, potentially equally destabilizing for our local economy, but that we weren't taking the kinds of actions and making the same kinds of investments. We had very little data on the scale of commercial rent debt in the county or the city. We decided to collect some of our own data, and in a survey conducted by our office with over 150 small business participants, we found that half of small businesses carrying rent debt owe over $50,000 in back rent. So it's huge amounts of money, especially for businesses that are often low margin businesses or that don't have a huge amount of cushion to be able to support themselves through times of difficulty. 3/4 of businesses that we surveyed were very concerned about the end of the commercial eviction moratorium. And only about 1/3 of those businesses had been able to renegotiate their leases with their landlords in a time of incredible need. We introduced a motion in response to these findings in May of this year, asking the city to look at policy solutions aimed at relieving this burden. And we're working with the Economic and Workforce Development Department on a program that will offer rent relief to small businesses and others that will ideally offer legal services to small businesses to be able to renegotiate with their landlords and to make sure that they're able to find ways to pay back rent. We're also excited to be working with our partners in Supervisor Mitchell's office to make sure that any policies coming out of the city are working hand in hand with the county's efforts on these issues. And we'll share more updates with all of you on these programs. I want to encourage everybody here, whether or not you're in our district, Council District 4, that you add yourselves to our Council District 4 newsletter, which often has resources that are relevant for the whole city, and so may be relevant for businesses and business owners who are attending this particular seminar. And you can sign up for the newsletter at councildistrict4.lacity.org. It's an easy sign up on our website. Ensuring that our small businesses have the support they need to thrive is a priority of my office. We've invested in it in our staff, even though we have a relatively small staff. In many ways, we've put a lot of time and office resources into this issue. And as we are nearing the end of a number of protections that have been in place, our office is doing proactive work, walking the streets, introducing ourselves to business owners, reaching out to business associations, and building relationships with businesses both in person and virtually. So if you are in need, if you have any questions that you want answered, please do feel free to reach out to our office, and you can call or find us via our website. And I look forward to working hand in hand with all of you, our broader business community, without which our city and county would not be thriving. and with Supervisor Mitchell's office to ensure that we can do the most in these coming months to exit this period of the pandemic with as much health as possible on every front. So thank you very much once again, and I'm looking forward to staying in touch with this whole community.
Thanks so much, Councilmember. We really appreciate your support and everything you do for our communities. Now I would like to invite Shashi from Public Counsel, who will be our first presenter today.
Can everyone see the slide now?
Yes.
Okay, I'm going to go ahead and go. Sorry about that. So what we do at Public Counsel, and I guess before I get into the specific small business work that we do, we're a not-for-profit law firm. We serve people struggling with poverty across Los Angeles County, and we engage in community advocacy, litigation, policy advocacy to address systemic poverty and civil rights issues. We work on a range of areas, including housing, economic development, education rights, consumer rights, and immigration, and community development, which is the team that I lead. So what we do in community development, as I was saying, is we provide free one-on-one advice, counseling, legal assistance, educational assistance, and legal publications to qualifying entrepreneurs, small businesses, including childcare providers, and nonprofits in Los Angeles County. We've been doing this work for more than 30 years. We're the only direct legal service provider in Los Angeles County that specializes in the needs of childcare businesses. We also have attorneys on our staff who specialize in the laws applicable to nonprofits and in advising small businesses. And the areas we work include choice of entity, entity formation, intellectual property, which includes patents and trademarks and copyrights, employment law, leases, vending contracts, and lending agreements. And so with COVID, we are definitely seeing and responding to the needs of small businesses that need help to renegotiate or terminate their leases, to negotiate back due rent, to understand their debt obligations, but also to answer their return to work questions related to their employees. The need has only been amplified by COVID, as you know, and we are here to help small businesses on their road to recovery. So I think I gave a couple different examples of the types of matters we can help with. In terms of large bulk of our matters that you can expect that we would likely be able to provide support on are workers' classification advice for in employment law, advice regarding hiring or leave policies, contracts, like do you have a service agreement? Do you need that drafted, or do you need some help with what the terms should be? Choice of entity, what is the form of entity that's most advantageous to meet your business goals? Leases, this is a common one, and this is the topic of this training. Do you need to renegotiate or terminate your lease? So the next question is, so that's, I think, a general overview of the types of services we can provide. We support both by providing services with our in-house staff attorneys, as well as by being able to leverage the resources and the expertise of the private bar. And so we're able to help with a wide range of matters, similar to, I think, what you'll hear from Tzedek next. And so we definitely encourage you to apply and just see if we can help you. So our application process is available on our website and as well by a phone intake. Applications are currently available in English and Spanish, but we are working to further expand that availability. We have an income eligibility threshold for our services that's based on the HUD definition of low income for LA County. You can go to the website here to apply, or you can always call our phone intake line where a live person will call you back if they don't answer the line. Also note that any information you submit on our application for legal services will remain confidential. We just needed to check eligibility. So I think we can go to the next slide. I wanted to also just share a couple of resources on our website that might be useful for you all. We have a section called Publications and Alerts, a section called Resources, and then we also have a specific page that we created with resources specific to COVID-19. One of the most widely accessed recently is our vaccination mandate alert, sort of telling you, can you or should you require a mandatory vaccination for your employees. So please don't hesitate to check that out. And I'm gonna, I think that's sort of the end of this training, but of my portion of just talking about what our services are and how you can access them. Public Counsel is really honored to be able to participate in this training, and we're really honored to work with Supervisor Mitchell's office and with Councilmember Raman's office and with Goodwin and Tzedek on these important issues. And so looking forward to a really educational evening. Thank you.
Okay. So hello, everyone. My name is Bria Stevens, and I'm a small business fellow with Tzedek's Legal Services. I'm here today to talk about our program, to talk about the Small Business Development Project specifically. So just to get started. So just for a little bit about Tzedek, it's a nonprofit legal services agency with over 40 years of history. We provide our services for free to individuals in the LA County area, and we cover a wide range of issues from the small business project to things like immigration rights and Holocaust survivors to employment rights. So we really try to be a very all-encompassing program and law firm. We provide our services regardless of anyone's race or religion or ethnicity or immigration status. And really just try to be as helpful as possible. So just to talk a little bit more specifically about the Small Business Development Project, just like a broad overview, it's designed to help low to moderate income entrepreneurs when transactional issues, so things related to corporate law. And we do this in a variety of ways. So we do things like these presentations, and we host workshops. We also offer direct client representation in combination with our network of pro bono attorneys, and I'll describe that in a little bit more detail. Starting this summer, we've been offering small business legal academies, which kind of combine our presentations with the direct client representations together. And then in 2020, we've just been able to grow and expand our project exponentially. And we've been able to do that with our partnerships. So in response to the pandemic, we've really just grown in a number of ways, from the amount of workshops we're able to do. We've been able to partner with a lot more with the vast network of community organizations and legal organizations, just to be as far reaching and as helpful as possible. And here what you see is just the list of all the various issues that we can help with. So again, we can help with transactional issues, but that's a wide range of what that means. So things like contract enforceability and commercial leases, which we're going to talk about today, and entity structure and intellectual property. So just a wide range of different types of issues that we can help address. And so then this is just going over how we can help, and then also going into more detail about our free client direct representation that I mentioned. So we provide, so another way that we can offer help is through our webinars, but also on our website, we have access to free FAQs and guides. So if you're just looking for some information really quickly, if you have a quick question that you want to answer to, or just something that you want to read at your own leisure, we have those on our website, and we have a link to that. I'll be putting it in the chat. And then just for a little bit more about the direct representation that we offer. So that's part of our program where we'll work to place you directly with an attorney to assist you with the issues. We do have eligibility requirements for that. We look at personal income, household income, and it's based on the federal poverty guidelines. We also look at business profits and sales. Another requirement that we have is that you have to be a for-profit business in LA County. So we don't assist nonprofits. I just want to highlight that. And again, I've mentioned this, but we help with transactional services. So that just means things that are not in the court. So things that are not related to litigation. And that link you see is the link to our application. And I'll be putting that in the chat. So no need to try to write any of this down. I'll be putting this information in there, but that's how you would apply for the direct client representation. And so then just to close everything up, what you see here is the link to the resources page. So again, if you do have some questions, we have guides up about intellectual property and bankruptcy and tax law, just types of helpful questions that that we anticipate that small business owners may have that you can look for guidance. And then you'll see the link to our application. So for example, this presentation is in general. So if you have specific questions about a lease that you are interested in or that you may want negotiated, or about back odorant that you would want to discuss, please feel free to apply for our program, our public counsel's program. We're both here to help, and we can get you some assistance for specific types of things, because again, this is just for legal information. And if you have questions, please feel free to email Nithya Segura. She's our program director, and she will be glad to help you and direct you in the right direction. Feel free to shoot me an email as well tonight if you do have some questions or concerns after today's presentation and you are interested in getting some more help following it. And with that, I would love to turn it over to Michelle Caswell from Goodwin Law. We are very happy to have her here today to talk about these commercial lease issues and different ways and that you can educate yourself about these different things. And so we're very glad to be able to work with you, Michelle. And I will turn it over to you. I'm just going to stop sharing my screen.
Thank you, Bria. All right, so as Bria mentioned, well, it's actually slightly confusing. My full name is Michelle Caswell Shea, but I am a leasing attorney at Goodwin Proctor, based out of our LA office. And I'm very happy to be here with all of you today for this commercial leasing presentation. I hope that everyone is staying safe and healthy during these unprecedented times. And I am hopeful that my presentation will be informational and helpful in terms of current leasing issues. While I represent landlord and tenants in various types of commercial leases, my presentation today will be focused on the tenant side. We have a lot of ground to cover, and I will be getting through as many questions as I can on my end at the end of my presentation. So if everyone is ready, I'm going to jump right in. First of all, I need to provide everyone with the following disclaimer. This is a general presentation. It should not be construed as legal advice because we are not considering the facts of your specific situation. If you have a particular situation on which you need advice, please reach out to Goodwin's Neighborhood Business Initiative to apply for direct representation. And listed here are the four main topics I will be discussing today. I will provide a brief overview of the commercial leasing process. Then I will take a deeper dive into essential lease issues. After that, I will go over some general lease negotiation strategies. And finally, I will discuss COVID-19 issues and tenant rights before opening it up to questions. So first is commercial leasing overview. First, I want to go over some basic differences between commercial and residential leases. One difference between these two types of leases is the use of the space. While residential leases are for spaces that people live or reside in, commercial leases include retail, restaurant, office, industrial, and many other uses. Another difference is how residential and commercial tenants are protected under state law. Residential tenants are afforded different protections under state law in comparison to commercial tenants. Specific civil code provisions apply to residential versus commercial tenants. And when I refer to civil code in this presentation, I'm referring to the California Civil Code. The main point to make here is that residential tenants enjoy much more significant protections under state law. For example, a residential lease includes what is called a warranty of habitability, while a commercial lease does not include this warranty. While a residential tenant's rights are primarily governed by state and local law, a commercial tenant's rights are governed almost entirely by the lease itself. This means that if the lease does not expressly require the landlord to do or provide something, the landlord will not be obligated to do so. Which takes me to my last point, that whether or not you are dealing with a commercial or residential lease, both types of leases should always include everything that has been agreed to between the parties in writing. Next, we move on to what I'm referring to here as the evolution of a lease. While the leasing process is sometimes not a linear process like what is shown on this slide, and the steps can be messy and jumbled, for purposes of our discussion today, this model shows the general steps for entering into a commercial lease agreement, and I will break these steps down further in the next few slides. The first logical place to start is identifying the need for a new space. Once making the initial determination that you need new space, you need to determine what size the space needs to be. And depending on the size and use of the space, you will want to choose a location or a few locations that are a good fit. And as I'm going to discuss further in connection with the last point on this slide, depending on the particular use, the location will be partially dictated by zoning law. Based on space availability and your own needs, you should determine a timeline of when you would like to be able to start using the space. And probably the most crucial of these points, you will need to determine what you're able to expend in terms of initial out-of-pocket costs for the space and what you will be able to afford in terms of continual monetary obligations during the lease term. And I will be discussing the potential monetary obligations when I get into essential leasing issues later in this presentation. You will also want to take into consideration what your parking requirements are for employees and or customers, and what other amenities you will want or need. Once you have an initial plan and have a location or a few locations selected, you will want to identify whether a potential space is suitable for your particular use. You should confirm what the potential space was previously used for and whether the space may be used for your specific purposes. You should also check the certificate of occupancy and zoning law, as well as confirm if there are any encumbrances that affect the use of the property. A tenant is required to comply with applicable law under the lease, so you want to ensure that your use will not cause you to be in violation of applicable law and that you won't be prevented from using the space for your particular business. Either simultaneously with or shortly after identifying the need for a space, you will want to consult a few professionals. You will want to enlist the assistance of a real estate broker as early in the process as possible. A broker will be able to assist throughout the entire process, including identifying available space and what is considered market for deal terms in the area. You do not necessarily need an attorney at the very beginning of the process, and depending on your budget and resources, some tenants may only be able to use an attorney for lease review. But in terms of initial steps, an attorney can help with permitting and licensing requirements, entity formation, and the review of any term sheet or letter of intent. You will want to consult your existing insurance broker or find a new insurance agent for your insurance needs for the space. Since you will be required to carry specific types of insurance under the lease, and insurance will be an additional cost that you need to take into consideration when budgeting for the space. Attorneys and real estate brokers may have baseline insurance knowledge, but they won't be able to properly advise on insurance requirements or provide the necessary insurance coverage. After determining which professionals you will be consulting with and when you will be enlisting their help, you will want to narrow down your list of potential spaces and work on putting together an offer, potentially with the aid of a real estate broker. If a landlord is interested in accepting your offer, you will then move to an agreement known as a term sheet or a letter of intent, an LOI for short. A letter of intent is a separate contract between the parties that precedes and is replaced by what is expressly agreed to in the lease. While a lot of actual negotiation takes place at the lease stage, the letter of intent typically sets forth the major business points, and what is listed here are terms you typically see covered in the letter of intent. So you have your rent, the lease term is the length of the lease, the premises is the defined space to be leased. You will want to set forth the expected delivery condition of the space and any restoration or surrender obligations. You will want to include any incentives or concessions the landlord is providing, such as improvement allowances and free rent. You will also want to include any options that are being provided, such as extension, expansion, or termination options. At this stage, the landlord may indicate a required security deposit amount or leave this open and subject to review of financials. The LOI should also include terms of crucial importance for your specific needs. And as I previously mentioned, the LOI is a contract, so it should contain language that it is a non-binding agreement until a lease is fully executed between the parties. In terms of additional considerations, you need to determine what type of business entity will be the tenant on the lease, such as a sole proprietorship, a partnership, a corporation, or a limited liability company. The named tenant on the lease may impact the exit strategy by insulating individuals from personal liability and by making it easier to sell the business. Depending on the creditworthiness of the tenant entity, landlord may require a larger security deposit and/or a lease guarantee. The tenant entity will also need to be registered to do business and be in good standing in the state where the property is located. I previously mentioned that an attorney can help with entity formation. Well, as part of this process, if an existing entity that will be the tenant on the lease was formed in another state, an attorney can similarly assist with registering that entity to do business in California or whatever state the space is located in. And that takes us out of the first topic and into the next one, which are the essential terms of a lease. This slide contains a list of basic lease terms, most of which I will discuss in further detail in the coming slides. However, I specifically want to cover the signage piece here. Interior and exterior signage rights should be covered in the lease, and similar to the permitted use, signage rights should allow for flexibility if possible, in the case the use of the space changes during the term. If a tenant is permitted to have an exterior sign or awning, the lease should also include language that the landlord cannot erect scaffolding or otherwise cover any signage for an extended period of time. Finally, it is important to note that the landlord may require that any tenant signage be removed upon expiration of the term of the lease, which is important to take into consideration in terms of future leasing costs. The first major topic I'm going to go over for essential lease issues are rent and other leasing costs. So fixed rent, what exactly is fixed rent? And when is fixed rent due? If landlord is providing a free rent or abatement period at any point during the lease term, this needs to be included in the lease. In terms of these provisions, the language should be carefully reviewed to ensure that a tenant will not lose an abatement right unless an event of default has occurred. When I refer to a quote unquote event of default in this presentation, this means that a tenant has defaulted under the lease beyond applicable notice and cure periods. A tenant should be aware of whether the landlord is requiring first month's rent to be paid upon lease execution. This is a relatively standard requirement and should be budgeted for, but if there's going to be a large gap between lease execution and the commencement of the lease, it may make sense to negotiate for tenant to pay first month's rent at a later date, but the landlord will still want this to be paid on or before commencement. The lease will also set forth how rent must be paid and when rent is due during the term, which is typically in advance and on or before the first day of the month. A tenant should confirm with landlord at the LOI stage what exactly is included in fixed rent amount in order to properly budget for the space. In a gross lease, the fixed rent will include the additional costs incurred by landlord, and the landlord will be responsible for paying any additional expenses associated with owning, maintaining, and using the property. In a net lease, which you may hear referred to as a triple net lease, the additional costs are not included in the fixed rent, and tenant is responsible for paying for operating expenses, taxes, and insurance in addition to the fixed rent. A tenant should also confirm what utilities are being provided as part of the fixed rent, and if tenant is going to be responsible for additional utility expenses. Finally, the lease should set forth who is responsible for certain repair and maintenance costs for the building and the premises, and this should be budgeted for accordingly. Now for rent referred to as additional rent, or rent that's in addition to fixed rent under the lease. If entering into some form of a net lease, the lease should set forth what can and cannot be included in operating expenses and tax pass-throughs. If tenant was responsible for this type of additional rent, the tenant will be responsible for paying its proportionate or pro rata share of these costs, which should be a percentage that is calculated by taking the rentable square footage of the premises and dividing this by the rentable square footage of the building. There are ways to try and reduce these potential costs, such as requesting that there be a cap on controllable expenses and/or requesting that landlord provide its standard operating expense exclusions. And depending on the landlord and how much bargaining power the tenant has, the lease should also include an audit right, which gives the tenant a right to dispute the operating expenses being charged by landlord and to audit landlord's books and records. If the tenant is going to be responsible for utility payments in addition to the fixed rent, it is important to determine and designate which utilities are currently metered or sub-metered, and how utility expenses will be determined if any utilities are not separately metered for the premises. If the landlord is going to be billing tenant for non-metered utilities, there should be no markup for landlord's determination and administration of these costs. Other than utilities for the actual premises, as part of the operating expenses, a tenant may also be responsible for its share of the utilities provided for the common areas of the building, which is also important to keep in mind when budgeting for the space. It is also important to ask the landlord and carefully read the lease for purposes of determining what costs the tenant may be responsible for in terms of additional services, such as HVAC that is used after the building's standard hours, including holidays, or above standard services that the landlord may provide. The lease should also specify who is responsible for what cleaning services, and if the landlord is providing cleaning services for the premises, what cleaning services are to be included. The lease should designate whether a security deposit needs to be provided in the form of cash or a letter of credit, or if tenant has the option to provide one or the other. If the landlord is requiring, or if the tenant is opting to provide a letter of credit, the process of obtaining a letter of credit can take up to a few weeks. So it is advisable to start this process with the bank relatively early in the lease negotiation process. It is relatively standard for the security deposit to be due upon lease execution, so this should be budgeted for as an initial out-of-pocket cost and taken into consideration if agreeing to a set security deposit at the LOI stage. Similar to the payment of first month's rent, if there is going to be a large gap between lease execution and the commencement of the lease, it may make sense to negotiate for the tenant to pay at least a portion of the security deposit at a later date. But a landlord may be hesitant to agree to this, especially if the landlord is providing any type of tenant improvement allowance or other upfront concession. If the landlord is requesting a large security deposit due to the credit worthiness of the tenant, a tenant could negotiate for a reduction or burn down of the security deposit if the tenant hits a certain milestone during the term. whether this milestone is based on the number of years that have passed or potentially based on tenant meeting a revenue threshold. It is important to carefully read the lease for purposes of determining when the landlord can use or draw down on the security deposit. It is standard for landlord to be able to draw down on a security deposit for both monetary and non-monetary lease defaults of the tenant. But similar to what I previously mentioned in terms of loss of tenant rights under the lease, a landlord should not be able to use the security deposit until an event of default has occurred, which again means that a tenant has defaulted under the lease beyond applicable notice and cure periods. The lease will typically provide that the landlord is not required to return the security deposit until after the expiration of the term and tenant's surrender of the space in compliance with the terms of the lease. There should be an outside date by which landlord has to return the security deposit so that the tenant's funds are not tied up for too long, especially if the tenant will be moving into a new space and tying up additional funds for security deposit for that new space. However, you typically do not see the outside date being less than 30 days. Section 1950.7 of the California Civil Code provides that if a security deposit in a commercial lease exceeds the first and last month's rent and is used to cover only defaults in the payment of rent, the portion of the security deposit in excess of the amount equal to 1 month's rent is required to be returned to the tenant within 2 weeks after the landlord receives possession of the premises, with the remainder to be returned or accounted for within 30 days after the landlord receives possession of the premises. So what does this mean? Most leases do contain a waiver of the section of the Civil Code, which allows for a landlord holding a large security deposit to apply the security deposit to future damages and prevents landlord from having to return the security deposit within the stated time periods. Without an explicit waiver of this section, if a landlord terminates the lease pursuant to California Civil Code section 1951.2, or after the tenant has breached the lease, the landlord is prohibited from using the security deposit as an offset against the amount of anticipated future damages. In addition to, or in lieu of a security deposit, and depending on the creditworthiness of the tenant, a landlord may require a guarantee. There are many types and forms of guarantees, the most common being a payment and performance guarantee, and they can be provided by a related entity or be provided by an individual. It is never advisable to enter into a personal guarantee because that exposes the individual entering into such guarantee to personal liability, putting their individual finances on the line. If possible, the lease should include the flexibility for the tenant to be able to provide what is referred to as a replacement guarantor. And there are ways for a guarantor to limit its liability, such as limiting the duration of the guarantee to a specific time period or capping the guarantor's liability at a specific amount. Now on to insurance. The lease will most likely require, at minimum, coverage for casualty, property damage, and liability, or damages to persons or property of others. You should ask your insurance agent to review the insurance provisions in the lease and to regularly review the policies to ensure compliance with the lease requirements. The lease will also most likely require this, but you should obtain a certificate of insurance as proof of current coverage and never allow coverage to lapse. You should also ensure that any additional insureds named in the lease, such as the landlord, are properly covered. When in doubt, reach out to your insurance agent with any insurance-related questions. Finally, you will want to review the lease for any other potential hidden costs, such as the cost of maintaining or repairing the premises, parking fees, and other costs and fees that are considered additional rent the tenant is responsible for paying for. All right, the next essential leasing issue I'm going to be diving into is in terms of the condition of the space. So first, we'll go over the condition as of the commencement date. The lease needs to specify the condition of the space. The lease needs to specify the condition of the space the landlord needs to deliver the tenant. The default for this is as is, which means that the tenant takes the space as is with all existing defects and without any landlord warranties as to the condition of the space. An alternative is that the landlord will be doing work to prepare the space for tenant's occupancy. If the landlord is going to be required to do certain improvement work, the lease should specifically designate, potentially in the form of what is referred to as a work letter, what work needs to be completed and the process for creating plans and specifications for the work. Landlord will be controlling the process, but the tenant should have approval rights over the plans and specifications, including the right to make change orders. An important piece of this is specifying who is responsible for paying the cost of the work, whether landlord is solely responsible for the cost or is providing tenant with a tenant improvement allowance and what the allowance may be used for in terms of hard and soft costs. It is standard for the tenant to be responsible for paying for its moving costs and the cost of obtaining and installing furniture, fixtures, and equipment for the space. If the landlord is doing the work, it is essential that it is factored into when the commencement date is to occur. In such instance, the commencement date of the lease should not occur until landlord delivers the space to the tenant with the work substantially completed in accordance with the approved plans and specifications. If a tenant has a time crunch for getting into the space and opening for a business by a certain date, such tenant may want to request penalties such as an abatement and/or termination right if the landlord fails to deliver the space by an outside date. Landlords are generally hesitant to provide such late delivery penalties, especially termination rights, and these penalties will most likely be subject to tenant delay and delays caused by a wide array of force majeure events. If the landlord is doing the work, a concept of tenant delay will most likely be incorporated into the lease. This will include a broad set of circumstances in which the tenant is considered to have caused a delay in landlord's completion of the work and will factor into the determination of the commencement date, meaning that if a tenant delay occurs, the commencement date will be the date that landlord would have substantially completed the work, but for the delay caused by the tenant. A tenant should carefully review the list of potential tenant delays to confirm it isn't too broad and to determine what the tenant should and shouldn't do. And the last alternative is if the tenant is doing the work. If the tenant has the capability to manage the initial improvement work, there will be a separate set of requirements that the tenant will be required to comply with for purposes of completing the initial improvements. And this work is generally treated as alterations to the space. The landlord will want approval rights over the plans and specification, including any changes made to the same. Similar to if the landlord is completing the work, the lease should specify who is responsible for paying for the cost of the work and if the landlord is providing a tenant improvement allowance. One thing I should particularly note in terms of allowances if the tenant is doing the work is that there will typically be an outside date by which the tenant is required to requisition the allowance, or the tenant will otherwise forfeit any unused funds. So it is important for the tenant to confirm that this date is acceptable given the extent and timing of the work that is planned. A tenant may consider requesting that tenant have the ability to apply unused portions of the tenant improvement allowance towards rent. If the tenant is doing the work, the lease will typically commence when the landlord delivers the space to tenant, so it is important that there is a separate rent commencement date. A tenant does not want to pay rent on space that they are still completing construction on and they are not actually using. So the tenant should determine a timeline for completing the work and being able to open for business when negotiating a rent commencement date with the landlord. Now on to the condition of the space during the term. There is no implied landlord duty to repair in a commercial lease. So this obligation must be contained in the lease itself. The tenant is typically responsible for maintaining the premises, while the landlord is typically responsible for maintaining and repairing the structure of the building, including the roof, the building systems, the lobby, and any other common areas of the building, with the costs for maintaining and repairing these items being included in the operating expenses for net leases. Alterations are improvements the tenant makes to the premises during the term of the lease after the initial improvements of the space have been completed. And landlords typically want consent rights for any type of tenant alteration. But a tenant might want to negotiate that the landlord not have consent rights if an alteration is cosmetic in nature, which will not affect the structure of the building or the building systems, and that is insignificant in value. There will typically be a separate article or section in the lease that sets forth what happens if there is a fire or other type of casualty in the premises or the building. The casualty section should include what landlord's restoration obligations are in terms of the timing of restoration and the condition the landlord is obligated to restore the premises to. Landlords and tenants' restoration obligations should track with the insurance requirements, meaning that if the tenant is obligated to insure any tenant improvements in the space, the tenant should be obligated to restore the same in the event of a casualty. The casualty section will always contain certain landlord termination rights, such as if the landlord is unable to restore the premises within a specified amount of time, or if the insurance proceeds will not cover the necessary restoration. Form casualty sections will seldom include tenant termination rights, other than potentially in connection with a casualty that occurs towards the end of the term. Tenants with leverage may want to consider negotiating for additional tenant termination rights in the event of a casualty. Now onto the condition of the space at the end of the term. Tenants want to avoid language and surrender provisions that obligate the tenant to deliver the space at the end of the term in good condition and repair. Instead, the surrender obligation should provide that the tenant is obligated to deliver the space in a similar condition as of the commencement date of the lease. Reasonable wear and tear and casualty damage accepted. The language I have in quotes that I just stated is really important to include in all of your leases. The lease will also most likely include what is called a holdover provision, which covers what happens if the tenant does not surrender and vacate the premises on or before the expiration date of the lease. During a holdover period, a tenant will be subject to a higher amount of rent and potentially consequential damages. With consequential damages on the line, a tenant should request that a landlord at a minimum be required to provide tenant with advance notice of the potential for consequential damages the landlord may incur as a result of tenant's holdover. The lease should set forth what the tenant is required to remove and restore at the end of the term in terms of improvements or alteration made to the space, including tenant signage that has been installed by or on behalf of the tenant. The lease should also include what the tenant can take with it upon the expiration or earlier termination of the lease, and the tenant should be entitled to take its personal property at the end of the term, such as furniture, equipment, and trade fixtures. The lease will also cover what happens if the tenant fails to take its personal property at the end of the term. The personal property may be considered abandoned, and sometimes the landlord can dispose of the same at the tenant's cost. It is advisable for a tenant to carefully read the alterations and surrender provisions to determine its surrender obligations, so that the tenant is able to keep the property they want and expect to keep, and because removal obligations can get pretty costly. The lease will most likely provide that the landlord can designate what is required to be removed prior to the end of the term, but a tenant can have success in negotiating this provision to instead provide that a landlord must provide such designation at the time landlord approves the applicable alteration rather than at the end of the term. All right, and now on to the third essential topic, planning for change. The standard lease often limits use of the space to a very specific purpose, what is referred to as a permitted use. All right, COVID-19, everyone's favorite topic. So the first thing here, and a lot of tenants have probably heard this since March of 2020, the necessary protections that are built into a lease that protect a landlord. Almost all leases contain a force majeure clause, and as a baseline, such clause provides some type of relief for performance by the parties in the event of something like an act of God, shortages of labor or materials, or other type of event that is out of the reasonable control of the party making a claim for force majeure. Some force majeure clauses only provide relief for landlord obligations under the lease. And even if a force majeure clause provides relief for tenants' performance obligations under the lease, almost 99% of the time, tenants' monetary obligations are carved out from such provisions, which in essence means that even in the case of a force majeure event, tenants are still required to pay rent. The reason for this is that based on one of the basic principles of commercial leasing, the landlord needs to have continuous receipt of rent from its tenant during the term of the lease without offset or deduction. And I'm not going to go into further detail on the other points on this slide, but these are other ways that we're seeing tenant raise claims in the courts right now for not having to pay due to COVID-19. All right, now I'm going to go over some important points on the current Los Angeles County eviction moratorium, which has very recently been extended through January 31st of 2022. But important to note, this is now referred to as the COVID-19 Tenant Protections Resolution rather than in an eviction moratorium. But it pretty much has the same protections in place of the eviction moratorium that existed prior to last week. Currently, a commercial tenant may not be evicted for non-payment of rent incurred during the moratorium period if the reason for non-payment of financial impacts related to COVID-19. As I stated before, the moratorium period is currently March 4th, 2020 through January 31st of 2022. And financial impacts include loss of revenue or business due to business closure, reduced revenues, or other similar reasons impacting a tenant's ability to pay rent due and increased cost. As the moratorium has evolved, tenants that are multinational, publicly traded, or have more than 100 employees are no longer protected by the moratorium. And tenants, if a tenant's occupancy is a threat to the public health or safety as determined by a court of law, that tenant is not protected by the moratorium as well. Any tenant seeking protection under the moratorium must provide notice to its landlord of its inability to pay rent due to financial impacts related to COVID-19 within 7 days after rent is due. And I'm going to skip over this information because this was already in place prior to last week's change. Just one thing to highlight here, the parties are encouraged to work out a payment plan during the moratorium period. And two things I want to highlight here is that landlords are prohibited from harassing, intimidating, or retaliating against tenants that exercise their rights under the moratorium. And while it only covered the LA County protections in place, if located within LA County, you'll want to confirm if your city has its own eviction moratorium currently in place that protects commercial tenants. And if located outside of LA County, you'll want to confirm if your county or city has an eviction moratorium currently in place. All right, I'll end on this slide. So what can't a landlord do if there is an eviction moratorium in place? Generally, a landlord cannot charge late fees, interest, penalties, or other fees on late payments covered under an eviction moratorium, nor can they serve a notice of termination on a tenant that is seeking the protections of the moratorium. What can a landlord do? Landlords are not prevented from requesting and accepting partial rent payments. And even if there are restrictions imposed on commercial evictions, in most cases, landlords may be able to seek to access tenant security deposits for lease defaults. Landlords can and have been suing tenants for breach of contract. Although the moratorium provides an affirmative defense, this does not prevent landlords from being able to sue their tenants. And most importantly, eviction moratoriums do not cancel existing rental obligations, but merely defer rent payments to a later date, which is why the parties are encouraged to work out a payment plan. All right, and I apologize again, I didn't get through everything I had on my slides, but I think it'll be most helpful if we open it up to questions.
Sure thing. Thank you so much, Michelle. That was an excellent presentation. So I'm just going to go up to some questions. Some have already been answered by Shashi from Public Counsel, which is great. And then some questions have been just a bit too specific. The first question that I see that has not been answered is from, hold on one second. It's from Vic. Vic asks, is there a rent relief offered to commercial tenants?
So I can take this at least from a legal standpoint, and anyone can jump in for in terms of programs offered by the county or the city. But from a legal standpoint, unless your lease provides it, there's or you renegotiate your lease with your landlord, you do not automatically get rent relief. And as I covered on my last point in the last slide, any kind of eviction moratorium does not necessarily provide complete rent relief. It just defers when rent payments are due.
Okay.
And Bria, if I could just jump in from our perspective at the county, as you heard from Councilwoman Raman at the beginning of the presentation, the city and county are working together to deploy a rent relief program specifically for commercial tenants within the next month, and should be made available well in advance of the end of January deadline for the eviction moratorium. Thanks.
Sure thing. So then the next question we have is from Destiny, and she asks, how can we get a further understanding about metered and unmetered utilities, and if they aren't listed as common areas? For example, if the breaker box and meter is addressed to my business address, are we considered the owner of the bill? And if so, how can we separate ourselves from other businesses?
So it sounds like the question is coming from an existing lease. So in terms of an existing lease, I would take a look at what the lease actually provides in terms of your obligations to pay utilities. If you have, it sounds like it's actually metered for your space and the bills are coming directly to you. So if the lease does provide you're responsible for paying those separate utility bills, it is your obligation. If, however, you're under what I refer to as a gross lease, which includes these utilities, that should be a landlord obligation. So in essence, you need to take a look at your lease and potentially discuss it with your landlord.
Perfect. Next question we have is from Brenda. She asks, what is a good metric to use to fairly build in rent increases? Is there something other than the CPI that more accurately reflects commercial lease rates in the area, given their volatility?
That is a much better question for a real estate broker, but CPI is what I typically see unless the rent increases were specifically negotiated at the LOI or at the lease stage. But again, in terms of like standard metrics, other than CPI, that's a question for a broker.
The next question we have is from Phyllis. She says, if you are having issues with noise disruptions and interruptions in the quiet enjoyment of your location, do you have any suggestions for that?
So commercial leases, even though they don't have something like a warranty of habitability, they'll have a quiet enjoyment provision in them typically. And this will typically state that a tenant has the right to the quiet enjoyment of their space so long as they're meeting their lease obligations. And in essence, the landlord cannot be the cause of the breach of the quiet enjoyment covenant. So if another tenant is the one that's causing the issue and it's not directly being caused by the landlord, what the tenant can do is reach out to the landlord to make the complaint. If it continues, the claim you can make under your lease, in essence, you would have to sue for this, is what's called a constructive eviction claim. Again, you would have to sue for this, and it can be timely and costly, but unfortunately, a quiet enjoyment covenant doesn't typically give you an abatement or like a termination right if the landlord violates it.
Okay. Next question asks, is it a good idea to use the standard commercial lease forms such as the AIR Commercial Real Estate Association forms, I believe?
So it is better to use something other than the AIR forms because they're the standard forms, and they do provide the necessary provisions. Unfortunately, usually what lease form is used is what the landlord provides. Unless you're a very large tenant, the lease form will be dictated by the landlord. So if that is what is being provided to you, you will have to use an AIR form. But that's not to say that you can't add an addendum or an exhibit to that form that specifies your specific provisions.
Okay. Next question asks, what are the provisions for rent or price increases under the current COVID-19 rent protections?
So I can only really speak to what's provided under the eviction moratorium. I know that there are some protections in the eviction moratorium that rent cannot be increased at this time. I can't really speak further to that.
Okay. I'm going through the next questions. A lot have come in since we've been talking, so I'm just catching up for a minute. Let me see. Another question says, is if a landlord for a commercial lease is not following the current law in terms of back rent, but so basically they're still requiring for rent to be paid, is that legal?
So, a landlord is free, and any party is free to do whatever they want, but it's not, if the tenant has properly followed the requirements of the eviction moratorium, meaning providing notice, and if required, supporting documentation of the financial impacts of COVID-19. As I pointed out before, the moratorium provides that the landlord cannot harass or intimidate the tenant, and they can't force the tenant out of their space, and that a tenant is not required to leave their space unless they are served with a 5-day notice to vacate from the sheriff's department.
Okay. The next question asks, must the 7-day notice of inability to pay rent be given each month if you're unable to pay?
Yes.
Okay. I'm just following up on some more questions. Another question asks, must repayment of rent by a tenant be spread over 6 over a 6 to 12 month period, or could it all be paid in the last month?
So the eviction moratorium isn't exactly clear on this. So if you work out a payment plan with your landlord, it'll be dependent on the payment plan. But if you are a tenant with 9 employees or less, you have 12 months following the end of the moratorium to repay past due rents. There's nothing in the moratorium that states they have to be made at specific times. The payments have to be made at specific times. If a tenant with 10 to 100 employees, they have to pay 6 months following the end of the moratorium. And I believe, I might be incorrect on this, for that specific type of tenant, the payments do have to be made in equal installments. I may be incorrect on that part.
Okay. The next question I have is there protection for self-storage facilities?
Yes. The eviction moratorium covers, like I said, it covers tenants with commercial tenants with less than 100 employees. It covers non-multinational and non-publicly traded companies. What it doesn't cover is also any property that's located at airports.
Okay. The next question asks, can I lose my business if I do not pay?
So the eviction, I'm guessing that means if they don't pay within the time period at the end of the eviction moratorium. So the short answer is yes. The eviction moratorium, whenever it ends and the protections of it end, if the tenant has not paid and is in default under the lease, the landlord will be able to terminate and evict the tenant.
Okay. One question asks, if you are experiencing harassment from a landlord during the moratorium, what are your options that are available to you?
So if I'm actually going to go back on this part of the slide because, and you'll be provided with the slides towards the bottom of here. The suggestion is to reach out to the Department of Consumer and Business Affairs if they're having issues.
Okay.
I'll leave that up for a bit.
Yeah. One question asks, if you gave notice last year when you deferred rent, for example, for May to July 2020, is that notice sufficient if you've been paying in full each month since?
So my understanding of the question is the notice sufficient as to the unpaid months? So yes, so if you provided only for those unpaid months, you're protected through the end of the moratorium period. And then the repayment is pursuant to like your tenancy size. But yes, then if you provided sufficient notice, then it still provides you protection now.
Okay. Another question is, if you're paying only part of the rent, do you still have to send in an unable to pay rent notice monthly?
Yes. Yes, unless you're paying full rent, in order to get the protections of the moratorium, you need to provide the necessary notice.
So one question says, if you have what if you have a month-to-month lease and your your landlord wants to enforce a 3-year lease, but does not want to cover a new AC unit? What is the California law on shared cost if the AC unit is an older unit?
I might need you to repeat that.
That's a specific question. If you have a month-to-month lease and the owner wants to enforce a 3-year lease and does not want to cover an HVAC system, or I think that's how you say HVAC
yeah,
system.
HVAC, yep.
If the owner agrees to negotiate shared cost of an AC unit, what is the California law on shared cost for those types of systems and units?
So going back to what I mentioned on one of my slides, there's not necessarily a California law that would cover it. It's what is included in the lease agreement itself. But the part of the question that I'm having a hard time understanding is that it was a month to month, but somehow becoming a 3-year term. So if it's a month to month lease, if you have a lease in existence, it'll be based on the terms of that lease. But if you're entering into a new 3-year term lease, that will need to be negotiated in the new lease of how the costs will be allocated.
Okay, so one question asks, can you explain how the recent COVID-19 tenant protections resolution applies to existing commercial leaseholders who are facing eviction for a COVID-related reason that is not related to their inability to pay rent? For example, mask requirements.
I would need further information on that. It's unclear on who's violating the mask requirements. If it's the tenant violating the mask requirements, it really depends on if the language in the lease around tenants' requirement to comply with applicable law. If it's truly a tenant non-monetary default, the landlord is able to evict at this time if it's not related to COVID-19.
Okay. Another question asks, where can we find resources for first-time commercial tenants? For example, if I need help with someone reviewing a commercial lease, well, you can come to Tzedek or Public Counsel. We can definitely help you for there. But Michelle, if you have other resources you want to share, but definitely just want to like that.
So Goodwin has a neighborhood business initiative that people can apply for representation through.
Okay. Another question is a commercial landlord required to provide heating and air?
No, not unless the lease provides that. Again, that goes to a warranty of habitability, which a commercial lease does not have.
All right. So I'm just going to take a few more questions. The second part of today's webinar is going to have one-on-one consultation. So just a few more questions, and then we're going to take a break to allow for that transition.
Bria, I don't know if we still want to allow time for Holly to speak.
Oh, yes. 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 Thank you for reminding me of that.
Yes.
So I'm going to ask maybe 1 or 2 more questions. And again, if we didn't hit your question, I'm sorry, so sorry, but please feel free to reach out to Public Counsel or to the Supervisor's office or to us at Tzedek, and we can definitely refer you to some more helpful resources and to give you the information or assistance that you may need. So I'll just ask 2 more questions and then I'll turn it over to the Supervisor. Let's see. So we have so many. One question says, do we have any read from the courts regarding do we have any information from the courts regarding how they will treat one missed or late notice of inability to pay rent due to COVID-19, where the tenant has otherwise been consistent?
Not really at this point. The courts are so backed up with cases and claims that I mean, as a business attorney, I don't really follow the docket, but our litigation counterpoints have been trying to keep track of this, and there's just not really much coming out yet, unfortunately.
Great. So we'll just end the questions with there. We have a lot more questions, but they're all kind of on the same thing. So thank you guys so much for attending. I'm going to turn it over to the Supervisor for her comments.
Good evening, all. I am thrilled that you all were able to participate. I looked at it was well over 100 people. I saw the questions. We need more time. Her slides were excellent. Don't cut her off. That means there was huge demand for this. And so I want to thank Councilwoman Raman and Public Counsel, Tzedek, and Goodwin Law. Clearly, people need information about how to maintain your businesses, maintain the integrity of your businesses, and what you can do to be supported. And so I'm going to keep this very brief because I want you to be able to roll into your one-on-one. And again, call these organizations directly if you need additional information. I hope that we were clear in this 1 hour at the end of your workday. Wasn't necessarily going to answer every question, but to give you access to the resources is what we want to do. Just very quickly, want you to know what we're doing on your behalf at the Board of Supervisors. This past June, I authored a motion focused on recovery and stabilization for small businesses. This motion set up stronger protections for small businesses that have been financially impacted to ensure that you aren't evicted due to inability to pay. The motion specifically targets relief for the most vulnerable, marginalized small businesses who have typically been either excluded or underserved by existing small business programs and loans. We're very excited about that. The board also approved over $70 million in American Rescue Plan funding, again, directly targeting I'm on my phone, and of course, a phone call came through, directly targeting small businesses, nonprofits, and community-based organizations. These protections and relief dollars are part of an intentional effort to stabilize business and to really reframe and redefine recovery. And lastly, I'll just say that I'm pleased that our county departments are working with the city of LA to roll out a commercial rent relief program that has a single portal for all businesses. This will reduce confusion by making a centralized access point for all businesses, regardless of whether you're in the city of LA or the county. I think we learned a valuable lesson with the residential rent relief program that first we were running. Now the state is taking it. The city has a separate one. Very, very confusing. And so I'm pleased that we've learned from our initial launch on the residential side, and this program hopefully will be much more efficient and effective and get resources into your hands more quickly. I want to thank Carmen and Carolyn on my team. I hope that they put their emails in the chat so you have a way to reach out and access them. Again, glad to be able to serve in our capacity as convener, bringing resources to the table, these partnerships, to make sure people have access to the information they need. Thank you again for participating, and stay tuned for the one-on-one support. Thank you.